Okay, so again, welcome to all of you. I really appreciate you taking the time to come and end your day and hopefully begin your night. Really happy to have Kirsten Howe with us from Absolute Trust Counsel. Um, I'm going to read her bio because otherwise I would forget to say all of the impressive things about her. She is the founder and managing attorney of Absolute Trust Counsel, a trusted law firm in Walnut Creek, not far away from all of us. Her practice focuses on estate planning, trust administration, probate, Medi-Cal planning, and special needs planning. Although Kirsten began her career as a business planning attorney, she soon realized that estate planning and elder law are her passion. She is dedicated to designing and implementing customized plans, making everything simple and easy for her clients and establishing close, long-lasting relationships. So Kirsten, I will put you in the driver's seat at this point.
All right. So I'm going to start sharing my screen. Here we go. Just bear with me. There we go. Can everybody see that? I hope you can. If you,
Yes.
Libby, you can see it. Okay. That's good enough. All right. So thank you so much for having me here tonight. I'm really glad to be able to present to you all. And as Libby said, as we go along, if you have questions, go type them into the chat. At the end, I will also answer questions. So if you don't want to type into the chat, or you don't know how to, that's okay. We'll stick around. I'll answer your questions. Don't worry about that. But you might want to write them down so you don't forget if you're anything like me. All right, so my presentation tonight is called Estate Planning Failures. Don't let this happen to you. And what we're going to cover is, first I want to talk about the basics of estate planning, just to make sure everybody knows what we're talking about. Probably most of you have this fairly well under control, but I just want to make sure that we are all speaking the same language. So I'll cover that. And then I have my top 5 estate planning failures. These are the things that we see over and over again that people do incorrectly that they could easily have avoided if they just had known. And so I'm telling you these things so that you can go through your mental checklist. Oh, did I do that? Maybe I need to take a look at that and see if this applies to me. And then, as I said, in the end, I'll answer any questions that you want to stick around and ask. Okay, so that's our agenda today. So basics of estate planning. What estate planning is about is planning for not only our deaths, but also for incapacity. And that's a very important point to keep in mind. We're thinking about death and incapacity. The most important thing when we're doing estate planning is to make sure that we are doing what you, the client, wants. Second to that is minimizing expenses, minimizing taxes, and keeping the family out of court. All of those things are what the client usually wants, but the most important thing always is what you want. We don't make choices to keep taxes low if they aren't what we really, really want. So these are kind of the overarching goals that we always have to keep in mind as we go along. And how we do that, for most people, a solid estate plan is, they're all different, but they consist of the same few components. For most people in California, we use trusts to do estate planning. And the reason for that is if you die in California and you own any assets, you own a bank account, you own a home, you own an investment account, if you die and you own those things, your family will have to do what's called a probate, which is a court process, because we have this problem of a dead person owning property. And that is a problem that we need a judge to help solve. So we end up doing a probate, we have to go to probate court. Probates take a very long time. I used to say, you know, a pretty simple one takes about a year, almost a year. That's not true anymore. I was talking to a friend of mine yesterday who said she just filed the final petition in a probate that it has been working on since last April. Very simple probate. And she got a hearing date of next May. Next May. It's going to be a 2-year probate. And that's because of COVID. So there's a tremendous backlog in the court. So probates take a really long time. Probates are very, very expensive because the attorneys get a share of the estate. And that's just the truth. That's why they're so expensive. And you don't want to do that to your family. So we don't want you to die owning any assets. And so we use trusts. By using a trust, instead of you owning your assets, your trust owns your assets. And a trust is not a person, so it's never going to die. So we're never going to have that problem of a dead person owning property. So the main component of a good estate plan is a trust. And we set up the trust, we plan it out. You have to decide what you want it to say. And it says all the things, you know, that you think of as being your will. What happens when I die? Who am I leaving my property to when I die? How old should my children be when they get their inheritance? All those kinds of things that you want to plan out and you want to control. And so that's written in your trust. And your trust also tells us what to do if you become incapacitated. With what do we do with all these assets that are in this trust? And who's going to manage it if we become incapacitated? So that's part of planning your trust. The other part is we have to figure out what assets are we going to put into the trust. And so we generally want most of your assets. We want your real estate. We want most of your bank accounts, investment accounts. If you own a business, that probably should be in your trust. The things that generally don't go into trusts are retirement assets, your IRAs and your 401ks or 403bs or whatever you have as a retirement plan. Those stay in your own name. So a trust helps us to avoid going to probate court if you become incapacitated. That's called a conservatorship. We don't want that to happen to you. And it helps us avoid going to probate court after death. And that's what we call a probate. So we don't want that. And that's why we use trusts. The next thing that we have in every good solid estate plan is a will. The wills are a special kind of will that works together with the trust. And the job of the will basically is to tell us what are we supposed to do with any assets that aren't in the trust. A lot of times clients will deliberately leave their checking account outside of their trust, and that's fine, but we need to know what to do with that checking account after you die. And so we read your will, and your will says, okay, put it in my trust. That's where I want my checking account. So that's the job of the will. The will also tells us who's going to file your final income tax returns. And if you have minor children, that's where you name a guardian for your minor children. Now, remember I said estate plan is going to cover not just death, but also incapacity. So every good estate plan needs to have a power of attorney. And in a power of attorney, you're naming somebody who can act for you if you become incapacitated. This person can do pretty much any legal or financial thing that only you can do. They can just step right into your shoes and start taking care of things for you. So, you know, they can start writing checks, paying your bills, something that important. They can also do, you know, the kinds of normal everyday things that only you can do, like calling up Comcast to add features to your account. You know, only you can do that. Comcast isn't going to talk to somebody else unless they have your power of attorney. So things like that. Every estate plan needs an incapacity component, and the power of attorney is one of those. And the last piece in a good, solid, basic estate plan that everybody needs is the healthcare piece. And what we need our clients to have is, and it's called an advanced healthcare directive. That's what we call it in California. And an advanced healthcare directive is a power of attorney, but you're naming someone who will act for you when you're incapacitated only in the medical realm. You're giving this other person legal authority to make medical decisions for you. And what I also do, and a lot of attorneys do, but not all, is my clients sign a HIPAA, which is a release that allows their doctors to share their private medical information with the person who is supposed to be making medical decisions for them. Legally, the doctors are not supposed to share that medical information with anyone. So I always have my clients do a HIPAA, so we have that base covered, because our medical information is protected by both federal and state statutes. It's since about 2000, I think, was when that was enacted. Anyway, okay, so now that is a good, solid estate plan. Everybody should have something like that, or most of those things. Now we're going to get into the real heart of the presentation, which is, oh, I shouldn't have my cursor up there, which is the failures. Okay, so I said there were going to be 5. Hopefully that's going to still be true when I get to the end of the PowerPoint. So failure number 1 has to do with funding. So I said a good solid estate plan is going to have a trust, and the transferring of assets to the trust is what we call funding. That's what that word means, funding. So if you have, for example, your home, you have a trust, your trust should own your home. You shouldn't own your home. Your trust should own your home. And how we transfer real estate to another person or entity is with a deed. So when you set up your estate plan and you create a trust and you own your home, you're also going to be signing a deed. And the deed says, I now transfer ownership of this piece of property from myself, Kirsten Howe, to myself, Kirsten Howe, trustee of the Kirsten Howe Trust. So I still own it, but I just am wearing a different hat. One of the very most common failures we see, because I do estate planning, so I help people plan, and I also do administration, meaning I help people after a family member has died. I help them do all that legal work that needs to be done. And almost in every case, when someone has died and they come in and they hire us to help them with the administration, there are assets that aren't in the trust that should have been in the trust. This is by far the most common failure. With real estate, this can happen because along the way, we refinanced the property. We got a new mortgage, and lots of people are doing that right now because mortgage rates are very, very low. And a lot of lenders will not lend to property that is owned in a trust. So when you do your refinancing in that big giant stack of papers that you're supposed to sign and understand, there might be a deed in there where you are taking your home back out of your trust. You set it up right, you put it in the trust, but now that you're refinancing, the lender is having you take it back out. So that's something to pay attention to. We've seen that many times, and it's very important if you have refinanced to go check that out. You can put it back in the trust. There's no reason, there's nothing wrong with that. The lender doesn't care if you do that. You're certainly free to do that, and you should do that. So I encourage you to check that. Another reason that sometimes we find real estate that's not in the trust is that after clients set up their trust, they inherited something from their parents. Now, they inherited a rental property. Didn't think to put it in the trust. And now that they died, now we have to do a probate. So we have a client who has a trust because they didn't want their family. And the last common reason that real estate sometimes ends up not in the trust is people buy new property. You know, that you set up your trust, you get your house into the trust, and then you decide, you know, this house is too large for us now. We're going to downsize. We're going to move into a condo. And you forget that you need to put that in your trust. So if any of those things have happened in your life since you did your estate plan, I encourage you to just double check and make sure that your real estate is in your trust. This problem with funding can also happen with any other kind of asset. And we almost always find it with a financial account, 1 or 2 bank accounts that just never got into the trust, or, you know, the client went to a new bank and opened up a bank account and forgot that they had a trust and that they really should put their bank account in their trust. So if any of these assets are outside of the trust on the day that you die, that's a problem, and we might have to do a probate. So how you can check on your financial accounts, your bank accounts, your brokerage accounts, is just look at the top of the statement where it says who owns this account. And if you don't see the word trust or trustee on that statement, probably it isn't owned by your trust, and you need to go and call the financial institution and take care of that. Sometimes when the amount of the value of the assets that aren't in the trust is small, we don't actually have to do a probate. There's another little procedure that we can do, but you don't want to take a chance. You don't want to take a chance on that. I just encourage you to get everything straightened out and cleaned up while you have a chance. Okay, so failure number 2 is having a plan that's out of date. I don't know if this is really failure number 2. It's maybe almost as common as failure number 1. And there are a lot of things that can make a perfectly fine estate plan be out of date. One of the big things is changes in tax laws, and we've seen that. We've seen a couple of really big changes in tax laws in the not too distant past. One of the big changes was in 2013. Our estate tax laws changed very dramatically in a way that affects married couples in particular. It made married couple trusts a little bit different. So before that law passed in 2013, we used to make married couple trusts pretty complicated. They had a lot of moving parts, and in 2013, the estate tax laws changed so that married couples don't have to have a very complicated trust if they don't feel like it. But I still see, even though 2013 was 8 years ago, every month I see one of these old trusts that's very complicated, and it needs to be updated. It's not what the clients want, which is fine, because you can always update your trust. That's your right. You can always update your trust until one of the spouses dies. And that, for me, is one of the most uncomfortable conversations that I have to have in my practice, is when a widow or a widower comes in and they show me their trust and they say, my spouse just died last month, and I have to tell them, oh, you have this really complicated trust, and now we're going to have to spend a lot of money following the terms of the trust, and you're not going to like it, and you're going to end up having to file an extra income tax return every year. You know, you're going to file your own, and you're going to file one for this trust. It's complicated. So if you're married and you have an estate plan and you haven't looked at your estate plan since before 2013, just just know that there might be an opportunity to update it and make it a little simpler. And it won't change anything tax-wise. You're still gonna have minimal taxes, but it'll just be a lot simpler. And simple means less expensive when you're talking about hiring a lawyer. That's just the truth. The other big tax law that changed recently was Prop 19. I'm sure a lot of you heard about Prop 19. Prop 19 changed the property tax rules for passing property between parent and child. It used to be that anytime real estate transferred from parent to child, pretty much without too much limitation, the property taxes would stay the same. The parent has been living in the house for 40 years. Their property taxes are very, very low. And then they die and the child inherits it. The child gets those same low property taxes. That's what the law used to be before February when Prop 19 was passed. And that's not true anymore. It's very limited, the situations where we can keep the property taxes low. So it's really important, if you have real estate that you are planning to leave to your children, that you check in with your estate planning attorney and just say, you know, what's going to happen now that we are operating under Prop 19? It's just going to be a very different situation. And there are things you can do to plan for it, but you've got to actually call and have that conversation. Just yesterday, I met with a family, new clients for me, and their mother had died in the middle of March, so after Prop 19. And the family had, I think, 4 different pieces of real estate. And all of those pieces of real estate are going to get their property taxes increased, unfortunately. And what's really unfortunate is that they were planning, at least one of the children was planning to keep one of the homes, because this child has been living in this home for many, many years. And so now, in order to stay living in that home, the property taxes are going to go up probably about $15,000 a year. That's a huge increase. That's huge. And you need to, you know, I mean, you can think what you want about Prop 19. I myself think that it was unfair in a couple of ways. It got jammed through very quickly. People didn't have a lot of time to plan for it. And also, people had been counting on the state of the law for many years, and they lived their lives planning for their children to inherit their real estate, and now suddenly that may not work. And so I'm not a big fan of Prop 19, but we're stuck with it. So if you have real estate, talk to your attorney, please, and get that straightened out. Another way that an estate plan can get out of date is when the assets change. And so here's an example of what I'm talking about. You know, maybe when mom and dad are in their 50s, 60s, they own a home and they have a big IRAs and they have a investment account. And then gradually over time, you know, they're spending that money down. And I've seen many families where when the second spouse dies, we get to the point where really there's a house and maybe just a bank account or a small investment account. There really isn't all that much. And that might be difficult for the family to administer that estate plan. It might be difficult to make it work the way the parents wanted it to work, particularly if there are multiple children. There are multiple children and just one house and a small bank account. Well, now you know the house is probably going to have to be sold because there's no cash to give to the other 2 children, multiple children. So these changes in assets, because we spend money over time, that's important to keep an eye on. Changes in fiduciary. So, you know, you have a trust you have a successor trustee, the person who will step in after you die. If you have a power of attorney, you have an agent. That's the person who will step in if you become incapacitated. You got to keep an eye on those who you've named in your documents. You might have someone that you named 20 years ago to be your successor trustee, and you don't even know where they are anymore. So those are reasons to update an estate plan. And this last one is I'm seeing this more and more, is changes in living situations. One of the changes has to do with people moving into your house, and people either remarrying or having a boyfriend or girlfriend move into their home with them. So you've got someone living in your home with you who you want to live there, and you care about them and you want them to have a good life, but they don't own the house. It's your house. And so what happens to their living situation if you die? You have to address that in your estate plan. Otherwise, kick them out. It's just something to take a look at. The other thing that I see more and more is when the adult children, move back in with their parents. So now you have someone living in your house who, again, needs to live there. You care about them. You want them to be okay. But if your estate plan says, I leave my entire estate equally to my 3 children, but one of them lives in the house, that's a problem. So it's just something that needs to be looked at. So my advice here is to just review your plan regularly. Take it out and read it. Does this still make sense? And if you're not sure, just schedule a short appointment with your attorney and talk to your attorney. It's worth spending a little bit of money to get answers to your questions. That's my advice. Okay, failure number 3 is beneficiary designation. So a lot of people don't think about this as being estate planning because it's not part of those 4 pieces that I was talking about at the beginning. It's not a trust, it's not a will, it's not a power of attorney, it's not a healthcare directive. But some of our assets pass on our death because we have designated in writing a beneficiary on those assets. So for example, I said way back in the beginning, we aren't going to put retirement assets into our trust. And the reason that we don't is tax. The taxes, we'd have to pay the entire income tax on that asset if we put the IRA or the 401k into the trust. So we don't do that. We keep those in our own names. And then we designate a beneficiary on those assets. So for example, let's say that you have an IRA at Fidelity. You would then fill out, when you set up that account, you would fill out a form at Fidelity and telling Fidelity, when I die, this is the person I want to get this retirement account, or these are the 2 people, or these are the 5 people. So it's very important to make sure that that you have named somebody as a beneficiary on those retirement assets, because if you didn't name somebody, it's going to go to your estate. There's no beneficiary. Fidelity doesn't know what to do with it. They'll write a check to your estate, and an estate is what goes to probate. So if you don't put a beneficiary on your retirement accounts, your family's going to have a probate to get those retirement assets. Same with life insurance. We all know this, how life insurance passes to the next generation or to the beneficiary is you actually tell the insurance company in writing, when I die, this is the person who's getting these life insurance proceeds. And so you've got to make sure that you have actually named a beneficiary. And my advice always is to name multiple beneficiaries. So you can name a primary beneficiary and a contingent or secondary beneficiary on life insurance and on retirement accounts. So I always have my clients who, when we're doing estate planning, part of the estate planning their homework assignment is always to double check all of their beneficiary designations and make sure that they are done and current. People change their minds. For example, if you got divorced at some point along the way, your IRAs, your 401k, your life insurance, maybe your ex-spouse is still named on that beneficiary designation. And that's probably not what most people would want. The divorce does not affect that. It doesn't matter. Fidelity is still going to give that IRA to your surviving ex-spouse if that's whose name is on their form. So very, very important if you've been through a divorce, and we have seen this, and there's really no way around it. That's what the paper says. That's what they're going to do. So if you've been through a divorce, double check on your beneficiaries. And then the other thing is beneficiary designations. If the person that you know you've written as the beneficiary on one of your accounts dies, take another look at that beneficiary designation and see if you need to make a change to it. You might not have to, because like I said, you might have listed a secondary beneficiary, but it's a good time to take a look at it and to reconsider what's the best thing to do. So again, in this respect, if these beneficiary designations fail, your family is going to end up doing a probate, and it doesn't matter if you have a trust, they're still going to have to do a probate to get these particular assets. And I've done quite a few probates of 401k accounts. And what's even worse than having to do the probate is that in order to get the 401k account, you've got to liquidate it, meaning you got to pay all that income tax on. You don't get to stretch it out. You don't get to take required minimum distributions. You don't get to do any of that tax advantage stuff. You're just going to cash it out and pay all the income tax in that 1 year. So definitely that's the worst asset to go through a probate, because you're not only paying income tax, you're also paying the attorney's fee. And it's a lot. It's a lot. Okay. Failure number 4 is really jointly owned assets. I put 2 different kinds of jointly owned assets on the same slide, and they have different problems. I don't see this so much anymore, but I used to see a lot of people who would do sort of, I would say, do-it-yourself estate planning. They don't want to do a trust for whatever reason. So what they do is they just do a new deed for their home, and they put their child on the deed, and the parent and child own the home as joint tenants. So in real estate, joint tenants means when one of the joint owners dies, the other one becomes the owner of the property, just automatically. They don't have to do a probate. There doesn't have to be a trust. It's just automatic. And so that can be good for some reasons. It certainly is a poor man's estate plan. It doesn't allow any subtleties. It doesn't allow you to plan for contingencies, but it can work. The problem, there are multiple problems with it, though, of course, or it wouldn't be on this slide. When somebody else owns part of your home, if that person gets into some kind of credit or debt problem, they have a bankruptcy, now your home is one of the assets that their creditors can come after. Or if they get into, say, a car accident, they get sued, again, your home is now one of the assets that their creditors can come after. If they get divorced, same thing. Now your home is an asset that's going to be part of their divorce. So all of those are things that most of us wouldn't like. But the one story that this is probably my most egregious story, so I'll share it with you. This was quite a few years ago. I had a client who came to me because he wanted to do some updating of his estate plan. And the story that he told me is that years before he had done exactly this. He didn't have a lot of money, so he put his son on the title to his home in Pleasanton as joint tenants. He only had one child, so that's, he figured that's safe. He's my only child. And that was fine. He went along, everything was fine, but he was on a fixed income and he started dipping into his savings. He didn't have enough income to support himself, so he was spending his savings down. And finally, he had gotten to the point where really he needed to get a reverse mortgage. A reverse mortgage is where you pull equity out of your home as cash and you get to still live in your home, but your home turns into like, a bank account. So he needed to get a reverse mortgage, but his son didn't want that because that was gonna, take equity away from this piece of property that the son expected to inherit. And so the elderly man, my client, asked his son, okay, fine, then just give me the home back. So I'm 100% owner and then I can get the reverse mortgage. And the son said, no, I'm not doing that. I'm not giving it back to you. And so this gentleman who's, I told you he's elderly and he's low on cash, he ended up having to hire a lawyer to sue his son. And he told me he never did. They settled the case, but he never did get the reverse mortgage. So that's a horror story, if you ask me. But don't add your child to your real estate. It's not a good idea for many reasons. What we do see, not that uncommonly, though, is joint accounts, particularly joint bank accounts. And a lot of times it makes sense. It's done for convenience. The parent will add one of the children onto the checking account so that the child can help with paying the bills. And that makes a lot of sense. As we get older, maybe we don't want to do that anymore, or maybe we're not able to do that anymore. And so you have the child on the account, and it makes it easy for everybody. But it's important to know that with a financial account, a bank account, if there are two owners on that account, when one of the owners dies, the account legally belongs to the other owner, which might be fine if you have only one child. But if you have two children or three children and only one of them is on your bank account, that could be a problem. It won't be a problem for you because you're dead, but it will be a problem for those children. And I have a case right now I'm working on where it was a very large account that the parent put only one of three children on. And a lot of times the one child will say, oh, well, I know that was just for convenience. It's not my money. It belongs to all three of us. But sometimes they don't. And that's what's happening in this case that I'm working on. The one child inherited a very large amount of money. The other two children didn't get any of that. And they probably destroyed their relationship among those three kids, that they're never gonna have Thanksgiving together again, is my guess, at least for a long time. So be very, very careful about adding somebody else onto any of your assets. Sometimes it goes badly. I'll just say that. All right, failure number 5 is not getting the incapacity planning as good as it could be. Estate planning, historically, we have focused on planning for death. But in the last 30, 40, 50 years, we have started living so long and suffering a lot of incapacity toward the end of life. That's become a very common thing. Dementia is a very common thing. And we really didn't have to deal with that 50 years ago. We didn't pay much attention to it, but now it happens a lot. And so we have to really pay attention to what is the plan? What's going to happen if I become incapacitated? So one of the things that we see a lot in the documents, in the trust, in the power of attorney, it will say something like, you know, if I become incapacitated, this person is going to step in. And this is how we establish that I've become incapacitated. And the most common thing that we see is when two doctors in writing say that I can no longer handle things on my own, that's when I'm incapacitated, and that's when someone else can step in for me. So that's very common, two doctors. And that can work just fine, but it can also be challenging for the family who's trying to step in and help their incapacitated parent, especially when we're dealing with dementia. It's not always easy to tell that someone is incapacitated. People can, people can get by. People can mask their symptoms of dementia very well, and they often do for a long time, such that, you know, if you're thinking, I think my mom really is incapacitated, I'm going to take her to the doctor. And your mom will come in and sit down in the doctor's office, and, you know, the doctor has whatever, 12 and a half minutes to spend with your mom. And the doctor asks questions and your mom answers, and she laughs and she tells jokes and seems fine. But you know that at home, at your mom's house, the dining room table is covered with bills that she hasn't even opened. She's not paying her bills. She's not managing. But the doctor may never see that. And if you've got to convince two doctors that your mom needs help when she doesn't really act that way 100% of the time. People with dementia have good days and bad days. That can be very challenging for the family. So what I always do with my clients is I talk to them about maybe there's another way that works better for your family to establish incapacity. For example, I had a couple who had 5 children, and their estate plan said, if 3 of our 5 children in writing say that we can't manage for ourselves, that's when everyone knows that we're incapacitated, and the next person in line can step in and take over. So they didn't have to go to a doctor. They didn't have to, wait until things were so bad that even a doctor who had 12 and a half minutes with their mom could see that she was incapacitated. They were able to really keep track of things and make that determination themselves. So it doesn't have to say 2 doctors. It doesn't. And this is something that I think is important for people to discuss with their family, and just make sure that what you're doing is what will work for your family, what they are comfortable with and what you're comfortable with. Very important to make sure that the people who are supposed to step in and help you if you become incapacitated have access to your documents. They just need to know where to find them, or maybe you give everybody a copy. You know, maybe the person who you've named in your power of attorney needs a copy of your power of attorney so that they can go and do what you need them to do. Make sure they have a copy of your healthcare directive. That's the one that sometimes needs to be handled very quickly. You are in the hospital and the doctor needs to know who's making the decisions around here. And you show up at the hospital, but you don't have that healthcare directive with you. So, make sure that the people who need these documents have them. And the last thing I'm going to say about estate planning failures, this applies across the board. Just update. You've got to update. This is by far the biggest, most common failure is a failure to keep things up to date. And if you're not sure if your plan is up to date, it probably isn't, and you probably need to check. So call your attorney, just schedule a little bit of time and ask them, is this still good for me? I hope that you will take that to heart and that you've learned something from this presentation. So now, I think that's the end. Yeah, if you have questions later, you wake up in the middle of the night and go, oh, I should ask you that. You can call me. So if you want that, and I think my PowerPoint will also be available to all of you as well.
Thank you, Kirsten. That was very informative. And I'm sorry if you were talking to me at one point, my screen froze.
Oh, no.
I really appreciate that. And I'm checking time and we have plenty of time for any questions. This is an opportunity for those.
Okay, so I will stop sharing and then people can you can just unmute yourself and shout out a question, or you can put your camera on and raise your hand, whatever you want to do. Yeah.
I have a question. I decided I wasn't so adorable, so you don't see my picture, but maybe I'll open it. So I'm Eileen, and I just wanted clarification about this whole, like, if something's not in the trust, probate, because I've been trying, my trust attorney retired and I haven't been looking at it for a long time, so the whole thing needs remodeling, and so I need to start over kind of. So anyway, if I have a trust, but I also have a taxable account developed because I have to take RMD and I'm not happy about having to take RMD. Anyway, and so I just left the money, it's all at Vanguard. So that doesn't trigger a probate for my whole trust. It just requires an attorney to take that one account to probate, right?
Yeah, that's right. If you have a trust and some of your assets are in the trust and some are not, but they should be when you die, only the assets that aren't in the trust have to be probated, and they might not have to actually be a full probate. If the total value of all of those assets that aren't in the trust but should be in the trust is less than $166,000.
Where do you find all those numbers? Who makes this stuff up? Like,
that's in the California probate code, so that's our legislature.
Yeah. Like, you would know it and like we would not. I mean, even with Prop 19, that whole thing.
Yeah.
And there are anyway workarounds, I guess, but I don't think I necessarily qualify. But yeah, there's.
Right. So there's another very short, easy-ish process if it's less than 166,000. It doesn't have to be a full-on probate, go to court, wait 2 years. If it's less than 166,000, we have another thing we can do. But you're gambling.
Well, is that a number, the 166,000, that can just float and increase and get different for the normal?
Yeah, it changes. It didn't used to change. It used to be, I think for a lot of years it was $100,000, and then they increased it to 150, and then they passed legislation that said it's going to go up every 2 years, indexed to inflation somehow. So now we're at 166. It's actually 166,250. So it goes up periodically. It never goes down, but it goes up. So you just, the better thing to do would just be to get that account into the trust.
Yeah, I know. It seems more complicated than. Yeah, I know that I should. Yes.
You should.
I'm shamed into doing it. I'm going to try.
Yeah, you said it in front of all these people.
Okay.
That's your assignment, Eileen.
I have a question. I have an annuity, and when I had my trust made out, the annuity is like payable to the trust. Like my bank accounts are in the trust, but the annuity is payable. But does that mean it's going to be taxed when it goes in there?
Annuity payments, annuity distributions are usually part principal and part income. So an annuity is you put a chunk of money into this annuity, and then at some point it starts coming out to you. And what comes out is a little bit of the principal that you put in and a little bit of the income that that money has been earning along the way. So that income piece of it is taxable. Yes.
So,
Whoever receives it will pay tax on that income.
so should I change it and just change the beneficiary instead of saying beneficiary to the trust? Have a beneficiary who's one of my relatives?
Well, you could. It just depends on what you want to happen. If you want that relative to get all that money, that's fine. You can do that. But you can have it come to the trust and the trust will pay the tax.
Okay.
It may not be a lot. I don't know. But depends on how much there is there.
Yeah, I have two questions. This is
Okay.
Dale. And one is, what kind of factors are involved with this Proposition 9 with, say, your house? If you now die and you said there was some tax complication there. I'm not sure what it is, but what options does a person have, working with your estate lawyer? Do they have ideas, or, I'm not really sure what the options are.
Okay. Well, I can give you a little bit of an idea. So what used to be true is that if you had real estate and you left it to your children when you died, in almost all circumstances, the property taxes would not go up. You had to have a lot of real estate before the property taxes would go up. Now, the law says you can do that with your personal residence only. You can leave your personal residence to a child, and if that child also uses that property as their personal residence, the property taxes won't go up in most circumstances. So it has really narrowed that down. It used to be you could leave a whole portfolio of rental properties to multiple children and the property taxes wouldn't go up. Now, the only thing that you can protect from an increase in property taxes is your personal residence. And you can only protect it if the child who inherits it makes it his or her personal residence. So that's a big, big change for a lot of people.
Yeah, that's a very serious change for a lot
Yes.
of people. I can see where a child may not want to take over a house that their parents lived in because it's old, out of date, and all kinds of reasons. It's not in the right state, or on and on and on.
Right.
So you're stuck with that. So what do you do then?
Well, the child can always sell the house. After you've passed away, the child can sell it. They don't have to keep it. The problem, and so then it's not a problem if the child doesn't want to keep it. It's a problem if the child wants to keep it,
Oh.
but they don't want to live in it, right?
Yes.
Or if they want to keep it, but it wasn't your personal residence. I have a lot of clients who they don't necessarily have a big giant 401k or an IRA. They spent a lot of their money investing in rental properties. That's a strategy. I have clients who have done that, and they might have 3 or 4 rental properties. Well, this doesn't apply to any of their rental properties. So they've been thinking all along, oh, my kids are going to inherit these rental properties. It's great. They're very profitable. I make $3,000 a month on each one of these rental properties. Well, guess what? If the property taxes go up $15,000 a year on each property, it's not profitable anymore.
That's right.
So yeah, a lot of people are getting burned by this. A lot of people.
Okay, the other question I have is just a sort of a general question. We have an estate plan, but it needs to be updated. And it seems like after listening to your talk here, there are a lot of items that need attention. Is the state attorney going to be overwhelmed when we come in and we have this list of 20 items to look at, or?
Oh, no. that's what we do. We do it all the time. Yeah. Your attorney will be very happy to see you.
Yeah.
They want you to have an up-to-date estate plan. It's really not fun for us when clients come in after somebody dies and it's a mess. We don't like that any more than you do.
Right. Sort of what's a rule of thumb, say like between the time when somebody contacts you and say, I want to update or change my estate plan? Is it like 6 months before it's done, or is it a year? You know?
In my office, it's usually about 6 or 8 weeks.
Oh, okay.
Yeah.
That's relatively quick then.
Yeah.
Okay. Well, thank you.
You're very welcome. Thank you for your
Kirsten-
questions.
Kirsten, it is 6 o'clock, and out of respect for everyone's time, feel free to jump off if you need to. Otherwise, if there are any final questions, feel free to let us know. I did include my email in the chat box if you want to follow up with anything. And we did get a question about your presentation notes, if it's possible to get those to send out.
My notes are up here. I can send the slides, but I don't actually have written notes. You give me a lot more credit than I deserve, I guess. So.
Perfect. Well, how about you send me your
I'll send the slides to you.
presentation, and then I'm happy to send it out to everyone who's joined tonight.
Thank you.
Thank you so much, and really appreciate you being
You're
Kathleen,
very
it looks
welcome.
like you might have another question.
No, I was saying thank you.
Yeah,
Oh,
thank you.
Thank
You're
you all
very
for joining
welcome.
tonight.
Thank you very much.
Thank you. You all have a nice evening.